we have a busy schedule today. Thank you all for being here, and thank for those joining online. Just for time's sake, appropriations will be in here at 5, so it looks like now we probably will run out of time to work bills today. And so I will tell you at the end of at the last testimony and announcements what bills we will be working tomorrow. Yes, we'll be here tomorrow. We have a hearing on 2 bills, and we will do our best to get out and get you all on your way as quickly as possible. So, anything else for the good of the committee right now? We welcome Representative Neighbor and Representative Tarwater and Representative Hoffman. Since we went to Representative Orpeza late yesterday, I didn't do that. So, thank you all, and you'll be here to learn a lot. Former Chair Hoffman, you know, you're not in the right position. Yes. You were in this room not too many hours ago. So, okay. So with that, we will open up the hearing on House Bill 2254, requiring milk processors to hold payments in a trust for milk producers until full payment is received. With that, we call on Advisor Kyle Hamilton for an explanation of the bill.
Thank you, Mr. Chairman, members of the committee. House Bill 2254 would require a milk processor to hold in trust all payments received from the sale of milk for the benefit of a milk producer from whom the milk was purchased. This would continue until the milk producer receives full payment of the purchase price for the milk. The bill would also allow a milk producer to require a milk processor to establish an escrow account for the producer's benefit if the following conditions are met. 1, that the producer actually sells milk to the processor, and there has been a failure to make a timely payment, that's a defined term, to the milk producer. The conferees will go into much more detail about this, but generally speaking, why would you want to have this sort of trust escrow system set up? It's so that the milk producers, the money that they should be receiving would be set aside and protected in case the processor, say, goes bankrupt. And creditors would be trying to get money from that processor, but the funds that should be going to the producer would be set aside and protected so that they could get that money maybe before the creditors. So funds held in trust by a milk processor or in an escrow account would be the property of the milk producer. However, a processor would not be required to maintain payments in trust or establish an escrow account under the Act if, 1, full payment of the purchase price is not received, and the milk producer does not give written notice to the milk processor by the end of the 30th business day after the final date for payment of the purchase price. And that's all the way back at page 3, starting at line 9, some of these exceptions. And then 2, a payment instrument received by the milk producer has been dishonored, and the milk producer does not give written notice to the processor by the end of the 15th business day after the day that the notice of dishonor was received. If an escrow account is created under the section, the processor would deposit all payments received from the sale of milk or dairy products into the escrow account until the producer receives full payment of the purchase price. The escrow account would be established as a segregated interest-bearing account with a financial institution in the state with deposits insured by federal insurance corporations. The milk processor might combine multiple escrow accounts into a single account if required to establish more than one. If the funds accumulated in the combined escrow account are insufficient to pay all the producers who have not received full payment and for whose benefit the account was established, the agent of the institution with whom the escrow account is established would be required to distribute the funds in proportion to the amount then due to each of those producers. Moving on to payment conditions, this is on page 3, line 19. Milk processors could only purchase raw milk if payment is made according to federal milk marketing orders and agreed terms. Payments made to federal milk market administrators on behalf of a milk producer would be considered as delivered to the producer. A few exemptions. The Act would not apply to transactions between cooperative associations acting as marketing agents and their members, and then milk processors failing to pay producers in accordance with the act would be liable for the purchase price, interest at the highest legal rate, and reasonable attorney fees. I should also note that in the bill's definition of milk producer, it would include any cooperative association that sells or markets milk on behalf of a milk producer. So the co-op itself could count as a producer. With that, I'd be happy to take any preliminary questions. Thank you, Mr. Chairman.
Questions for Mr. Hamilton? You do. Yeah. Representative Neely?
What happens if the processor's out of state or something along those lines?
If, from what I understand, if they've received milk from producers inside this state, this would be applicable.
Other questions for Kyle? Seeing none, thank you. Calling Heather O'Hara for fiscal information.
Thank you, Mr. Chairman. The Department of Agriculture indicates that enactment of the bill would have no measurable effect on agency operations. However, the department indicates the bill would impose a monetary burden which could create a deterrent to milk plants conducting business in the state or those considering Kansas for future development. The department states that the bill could ultimately lead to lost fees for the agency if businesses moved out of state.
Any questions for Heather? Seeing none, we'll proceed with proponents. Up first, Aaron Popelka from the Kansas Livestock Association. Welcome back to committee.
Thank you, Mr. Chairman, members of the committee. I'm Aaron Popelka with the Kansas Livestock Association. This might be my first time here this year, and so for those of you who are not familiar with our organization, we represent livestock producers across the state. A big focus is the beef industry. But we also have swine producers, and today, here to talk about our dairy producers. I think the reason for this bill, some of you, particularly maybe from Southwest Kansas, may recall early last year, there was a dairy processor, Kansas Dairy Ingredients, that defaulted on payments. And I think after I'm done here, you'll hear from one of our members who lost substantial payments during that default. And so through our membership processes and our convention, our dairy producers asked us to come and ask you all to enact this trust law. So I think the reviser Hamilton did a great job in explaining this. And I think essentially the way to think about it is right now, if I'm selling to a dairy processor, and that processor defaults, declares bankruptcy, I'm essentially, the funds that I'm owed are potentially able to be clawed into bankruptcy and sent to a creditor. What this does, the trust, if you will, is a statutory trust that essentially says these funds are not the funds of the processor, they are the funds of the producer. And they're supposed to be in any products that flow from the raw milk, so think cheese, milk, that are then sold, those proceeds then belong to that producer. For those of you familiar with the beef industry, we already have these trust mechanisms at the federal level. The Packer Trust, Market Trust, Dealer Trust, those are administered by USDA. Milk producers do not have those protections, although some states have taken the step to do this, Texas being one. And so when we worked to put this bill together, we know that at least a couple of our large processors here in Kansas do business in Texas. And for continuity purposes, we decided to model this on Texas's law so there would be some consistency for those operators. The one thing I will note that is different than the Texas law is on page 3 at line 1, and it talks about that escrow, the escrow is not triggered until a payment has been missed by 3 days. So Texas allows you to ask for that escrow at any point. And working with some of the processors here in Kansas, we didn't want it to be a financial burden. I think as perhaps the department thought it might in the fiscal note. But we believe, working with the processors, this slight change from Texas law, the trust will still work. The escrow just won't kick in until there's been a late payment, and so that will avoid any upfront capital costs. The one thing I might also note, this is probably more for the revisor and perhaps you on the committee for a technical amendment. On page 1, line 28, I believe there is a cross-reference that maybe need to be corrected. It says subparagraph big A, and there is no big A. I think that should be probably a reference to subparagraph 1. But other than that, Mr. Chairman, I'm happy to stand for any questions at the appropriate time.
All right, Aaron, thank you. Any questions for Mr. Palka? Representative Mosley.
Thank you, Mr. Chairman. You mentioned one instance that a dairy, there's a lot of P words, producer wasn't paid by the processor because the processor declared bankruptcy. How widespread of an issue is this actually? Because that's one instance. And obviously, to quote the great Rihanna, you better have my money, essentially. But how widespread of this, how widespread of an issue is this for producers?
Well, I think these are the things that tend not to happen very often, but
Okay.
that when they do happen, they tend to be very significant and severe for the producer. You'll hear from one of our producers here, I think, in a minute, who is caught up in that, and I'll let him explain the impact on his operation. They're rare, but when they happen, it's not good for the producer.
And I'm also unfamiliar with how cash-rich processors are. How does this not create an undue burden to processors if they're having to lock up money, lock up funds in a trust account?
Well, and I think that's maybe going back when I said, if you look at the page, top of page 3, so the trust, essentially, it's not an account from the outset. It just says that the proceeds from that raw milk are held in trust. It doesn't mean there's an account. And then the limitations on the actual account, which is the escrow, don't kick in until there's a late payment. So that was a concern before we asked for this bill to be introduced. We worked with some of the milk processors, and that was their concern. We don't want to have any front-end capital requirements, and so that's the solution there on the top of page 3.
And then are there any obviously processors are probably not as excited about that. Are there any processors that are pro this bill?
Well, let me put it this way. I'm not aware of any that oppose the bill at this point, but I also don't have the chair's list, but I'm not aware of any. We've tried to work with and reach out to as many processors as we could.
Other questions? Have one. What about, there was a little discussion about a bond. What can you explain why this trust is better or different than, say, having a surety bond or something along that line for payment?
So there is no bond requirement in this statute. So going back to the beef industry, for, let's say, dealers or packers, there is a bond that they would post with the regulatory agency that says, and I forget the percentage on dealers, but it's a percentage of their dealings that says if we go bankrupt, then this is available to make producers whole. That obviously has a capital requirement on the front end and requires agency involvement. That's not in here. One, I think the good thing about this is it really is a self-help statute where it doesn't require the government to monitor anything. It's essentially in the event of default. I get to go, let's say it goes into bankruptcy. I can go make a claim in bankruptcy court with the bankruptcy trustee and say, hey, these proceeds are ours and don't belong in the bankruptcy estate.
All right, other questions? Seeing none, thank you. I know you have another committee to get to, so appreciate it.
Thank you, Mr. Chairman.
Up next, Janet Bailey with Kansas Dairy. Welcome back to committee.
Mr. Chairman, members of the committee, thank you for the opportunity to be before you today. I would also like to thank my colleague from KLA and the KLA membership for bringing this bill forward. My dairy producers also adopted policy to support the concept of what is brought forward today. The Kansas Dairy Association, it has been in existence for 3 decades. And during that time, we have represented dairy producers border to border. There has been a lot of change over those 30 years, but what has remained consistent is that dairy producers have a desire to get together and figure things out. And sometimes that means there are challenges in the industry that aren't necessarily easy, and so they have to figure things out in less than ideal conditions. And so I stand before you, before a producer shares his specific experience, to tell you the reasons why we support this bill, but also just to tell you a little bit about how dairy farmers in Kansas market milk. I will spare you the federal milk marketing order education because you all have a session to finish, and we would be here with far more experts with a lot more time than you have this session. But let's just say the milk marketing order system is complicated. But what we need to know today is that producers market milk in Kansas really essentially one of 3 ways. They either market directly. For instance, they have raw milk from their farm and they are shipping to a processor, and you will hear from somebody who did that. They market cooperatively, so they are a member of a cooperative association, and they ship either to a transfer station or they ship directly to milk silos for that milk to be commingled with milk from other farmers and be processed into that fluid milk, cheese, ice cream, and other products you enjoy, or potentially to be made into powder, which is an important part of our industry in Kansas, or they are processing on farm. So they have their own milk going into processed products, and we do have farms who are doing that with on-farm processing. It's far more limited, but it is occurring in Kansas. So that's the sphere that we're working with. The instance that Mr. Popelka referred to and the one producer that actually was caught in this bankruptcy, I will share with you, there were additional producers who had marketed, but there were also member cooperatives, because dairy farmers harvest every day, and there are a lot of influences that fluctuate how much milk is given at any point in time, and they've got to move that milk to where it's needed. And so at the point in time that there was there was milk that their co-op needed marketed, there was some milk marketed by some Kansas cooperatives to the entity that filed bankruptcy. So this is more than just one farmer who was impacted, although when that was your sole market, the impact is great. We did have cooperatives as well who were not paid for their milk and were on page, they were several pages down in the bankruptcy, I will say that. So they had to absorb those costs as well. Obviously, milk marketing can be challenging and stressful for dairy farmers. There are risk management tools. This bill addresses, as Mr. Popelka said, a self-help opportunity and puts in statute a remedy when things go wrong. And it gives onus upon the producer with their legal counsel to pursue in bankruptcy the funds that would be escrowed from the proceeds of products that were sold. So we appreciate that this is not an additional financial burden to what can be a very slim margin industry, but it allows for those proceeds from the sale of products to be escrowed such that producers can be made whole. And many of you who are familiar with bankruptcies know that oftentimes it's very easy to overlook the input provider in a bankruptcy, and it's very important that we make our farmers whole when we have a bankruptcy like this, or the community impact is tremendous. With that, I would be happy to stand for any questions the committee may have.
Any questions for Ms. Bailey? Representative Mosier.
Thank you, Mr. Chair. Thank you, Janet, for your presentation. A couple of questions. How many milk cooperatives are there in the state, and do the number of producers within each cooperative vary, or are they roughly the same size?
Milk cooperatives, the number off the top of my head, and I would have to get back to you with the exact number. I mean, I can think of at least 4 or 5. In addition, we have some entities that create what is a producer association. So a processor may have membership, and if you read Kansas dairy law, then you'll understand some of why they do that. Within those cooperatives, they ship milk, as Mr. Popelka said, some of that milk does leave Kansas. In fact, a lot of milk leaves Kansas. Producer numbers in cooperatives vary greatly. The size of the cooperatives vary greatly. And where that milk goes also varies. Additionally, we have some cooperatives that have relationships with different processors, both in-state and out of state, and sometimes those cooperatives may have to work with one another to get the milk where it needs to go.
Thank you, Mr. Chair.
Very good. Other questions? Seeing none, not to push you on, but we've got a big agenda today, so thank you so much.
Thank you.
Joining us now via WebEx is Brian Hemmen, who is also a member of the Kansas Livestock Association. Mr. Hemmen, are you on the line?
I'm here.
Okay, go ahead. Welcome to committee.
All right. Good afternoon. Thank you, Chairman and House members, for your consideration. My name is Brian Heeman. I'm a local dairy farmer in Southwest Kansas and also president of Lone Star Milk Producers. Our family alone milks over 13,000 cows and produces over 1 million pounds of milk a day. Our co-op is almost 100 times that. As you know, we produce a perishable product that must be delivered daily. We do not receive payment for that, sometimes up to 45 days after the first part is produced. So what this bill will accomplish is allowing us to continue to get paid for our milk as it goes to these processing plants. Because as you know, it's perishable, so we don't have the luxury of putting it in our storage bins for grain and waiting for another market. So whether that is to help the existing processor work through some issues or for us to find an alternative home, it would keep us from, ultimately, we could either deliver to that processor, not knowing if we're going to get paid, or we would have to dump it down the drain. So this bill would actually give us some solutions to that. In the case of KDI, there was over $5 million worth of milk that was not paid for. And through that, and not having a working solution for the community of Hugoton, over a couple hundred jobs were lost in the size of a town of 3,000. We do believe that this bill would help mitigate some of these issues. It doesn't solve the problem of bankruptcy, but it would allow a workable solution to move milk into different locations without the greatest financial hardship. And what it does is actually it takes the funds that is received from the sale of products. So basically, our milk would go into that product, and so that's the reference that in a way it is still ours. It doesn't attach to buildings or anything else that banks and stuff may be attached. I did hear one other concern that it might limit processors and stuff coming into the area. But this bill, as I said, mirrors or is very similar to the one in Texas. And as you know, we have Hillmar Cheese has already been established in the state of Texas. Cacique Cheese recently built a new plant there. Leprino Cheese is currently opening a brand new large facility, all of which are 10 times larger than the facility that we had this issue with. So I don't believe that the bill would deter any growth in the area as far as the dairy industry is concerned. So with that, I wanted to keep it short, maybe open it for questions. If you had some specific questions of me, that would be great.
All right, thank you so much. Any questions for Mr. Hemmen? Seeing none, thank you for taking time to join us today, and we'll follow up if we have other questions after this. So thanks again for joining us.
Thank you.
All right. I see any other proponents here on House Bill 2254? Seeing none. Anyone wishing to testify as a proponent? Seeing none. Anyone wishing to testify neutral on this bill? Seeing none, we'll close the hearing on House Bill 2254. Now we move on to House Bill 2174, enacting the attorney training program for rural Kansas and more. So we call once again on Kyle Hamilton to brief us on the bill. Thank you.
Thank you, Mr. Chairman, members of the committee. House Bill 2174 would establish 2 programs as part of the Attorney Training Program for Rural Kansas Act. First, it would establish the Law Student Training and Loan Program for rural Kansas, and 2, the Attorney Training and Loan Repayment Program for rural Kansas. Section 1 contains the purpose of the act and some key definitions. One important one, the term rural or rural community would mean any county of this state other than Douglas, Johnson, Sedgwick, Shawnee, and Wyandotte counties. Section 2 would establish an advisory committee to assist in the administration of both of the programs. The advisory committee would consist of 7 members appointed by the Chief Justice of the Kansas Supreme Court, including 3 attorneys residing in rural communities, 2 non-attorney members residing in rural communities, and representatives from Washburn University and the University of Kansas Law Schools. The Office of Judicial Administration would provide necessary staff support, and the Chief Justice would appoint the chair of the advisory committee. The advisory committee could meet at any time and place upon the call of the chairperson and could adopt rules and regulations necessary to implement and administer the programs. Section 3 would establish the Law Student Training and Loan Program for rural Kansas. This program would be administered by that advisory committee in coordination with Washburn University and the University of Kansas for each university's respective law students. The program would authorize each law school to enter into program agreements with qualified law students. Preference would be given to Kansas residents. Subject to appropriations, each student that enters into such an agreement would receive a loan in an amount not to exceed $30,000 per year for not more than 3 years. This loan would be for the cost of tuition, books, supplies, and other school expenses associated with pursuing a law degree. If the student satisfies the obligations of the program, the loan provided to such student would be deemed satisfied and forgiven. The program agreement would require law students to complete their law degree, require training, an externship, and engage in full-time practice of law in a rural community for a specified period. In the bill, page 3, line 12, it says that that period would be for at least 12 continuous months for each separate year that a student received a loan under the program, unless such obligation is otherwise satisfied. So at least up to 3 years working in a rural community. The service obligation required by the program would be satisfied if the obligation to practice law is completed, if the individual is unable to practice due to a permanent disability, or if the individual dies. The service obligation could be postponed during any period of temporary disability. The reason for postponement is covered by the Family and Medical Leave Act or for a reason agreed to in the program agreement. The Dean of the Washburn School of Law and the University of Kansas School of Law would annually submit a report to the legislative committees on judiciary concerning the program. Section 4 would establish the Attorney Training and Loan Repayment Program for rural Kansas. So the first program, again, we're talking about law students. This second program, it's focused on attorneys who are already out there. This program would be administered by the Office of Judicial Administration in coordination with the advisory committee. For up to 5 years, the program would provide loan repayment assistance of up to $20,000 per year, not exceeding $100,000 in total for eligible rural attorneys. To qualify for the program, an attorney would be required to apply, hold a law degree, be licensed in Kansas, have outstanding student loan debt, and reside and practice law in a rural community. The program would require eligible rural attorneys to enter into an agreement to practice law in a rural community for 1 year for every year the attorney received the loan. Each agreement entered into would include penalties for breach of contract. The service obligations required by the program, again, would be satisfied if there's a permanent disability or if the recipient dies, could be postponed for the listed reasons. And again, the Office of Judicial Administration would be required to report to the Legislative Budget Committee and the Legislative Committees on Judiciary on the program. The report would include the amount of monies allocated, the number of attorneys who applied, the number of attorneys who received a loan, how the monies were used, and the process for the allocation of monies. Then Section 5 would establish the attorney training program for Rural Kansas Fund administered by the judicial administrator for both of those programs. Monies in the fund would be expended only for student loans for law students who enter into an agreement or student loan repayment for licensed attorneys who enter into an agreement under the Act. House Bill 2174 would become effective upon publication in the statute book. With that, I'd be happy to take any preliminary questions.
Any questions for Kyle right quick? Representative, I know, I was just, dramatic effect, dramatic pause. Representative Weigel?
Thank you, Mr. Chairman. I have a question. I guess it's related to Section 4, which, if I understand that, applies to attorneys who are already practicing law and still hold student debt. Are there other similar programs for other professions in the state? Like if you have a social worker out in those communities or a medical provider that...
I'll have to double check, but I believe there is a current program for veterinary students. Is that correct?
And MDs.
Okay.
But can I ask a quick? Can I ask?
Yeah, go ahead.
And
Yeah.
and just to clarify, that's not just for people who are in school who are planning to go practice, but you're saying there's other programs out there for people who are already practicing their professions but need help with their loan relief?
Some of the other conferees might be able to circle back with specifics. I would have to double check.
And maybe we'll get that in those that will testify. Other questions? Seeing none. Heather?
All right. Thank you, Mr. Chair. The Board of Regents indicates enactment of the bill would have a minimal fiscal effect on the universities. The Office of Judicial Administration, for their administrative costs, they estimate $187,000 in fiscal year 2026, and they would require an additional position. For the programs itself, for the attorney training and loan repayment, 20 attorneys times $20,000 would equate to $400,000 in FY 2026. For the law student training and loan program, 10 students in fiscal year 2027 times 30,000 would be 300,000. They estimate 20 students for 2028, that would be 600,000, and 30 students for 2029, which would be 900,000.
Okay. Questions? Seeing none, thank you. We will now go to proponents, and first joining us is the Honorable K.J. Wall, who is from the Justice on the Kansas Supreme Court. Welcome to committee.
Thank you, Chairman and fellow committee members, and I appreciate the opportunity to speak in support of the proposed legislation, HB 2174. I submitted written testimony to you where we really sort of, well, I am a justice on the Kansas Supreme Court, but I also chaired our Rural Justice Initiative, which was a large committee that studied the attorney shortage across our state and rural communities for the better part of 2 years. That committee has released a full report that has documented the severity of that shortage. In my testimony, I identified some of the more startling statistics that the committee uncovered that documents the severe shortage of attorneys in our rural parts of our state. Also, the written testimony showed why education debt and tuition cost creates a substantial barrier to recruiting attorneys to those communities. And again, summarize the components of the legislation that targets that barrier and identifies other programs in the state that this legislation is modeled after, like the K-State Rural Vet Program, like KU Med's Rural Physician Program, that have proven to be successful, and we believe it can be successful here as well. But I don't want to just repeat that testimony. Instead, and I know time is short, so I just wanted to identify some of the reasons why I think this legislation is important for our state as a whole. And the reason has to do with the impact that these attorneys can have on their communities. First of all, having an adequate level of attorneys in rural parts of our state is important economically. These attorneys help businesses operate and to expand throughout our state. And all of you know from your work on this committee that we have sophisticated business operations throughout rural parts of our state in the agriculture, energy, and other sectors. And they need legal assistance to get that work done and to continue to operate and grow. In addition to that direct support that attorneys provide to those businesses, they are also, in many instances, small business employers in these communities. They're running their own law firms and employing support staff from members of the community. And in addition, they have an economic impact because many of these rural attorneys reinvest in their own communities. I'm sure you'll hear from other proponents of the legislation who are currently practicing in rural parts of our state that reinvest in, they create title companies, they reinvest in food franchises, you name it, but they put their roots into the community. Besides the economic impact that these rural attorneys create, there is a larger community impact. If you look across the state at our critical access hospitals, local school boards, you will find these rural attorneys serving on those boards, providing those organizations guidance and trying to ensure that they remain anchors of the community that keeps those organizations vibrant. And finally, we need more rural attorneys across our state to help us fulfill a constitutional obligation, and that is the right to counsel. Everybody knows the United States and Kansas Constitution in many of our criminal cases ensures the right to counsel, and that means that a judge needs to appoint counsel if the party cannot afford the attorney. The legislature has also guaranteed the right to counsel in many other cases, like child in need of care proceedings, for example, which can require multiple attorneys for just a single case. And our local judges have to look for counsel in their communities to fulfill that obligation. And currently, they are stretched to their absolute limits, finding very creative ways to get attorneys in our rural communities appointed to cases. And usually, the best outcome is you find an attorney that will take the appointment, but they are also taking appointments in numerous judicial districts all across the state, which causes substantial delays that creates new concerns of a constitutional dimension, such as speedy trial, and the whole phrase, justice delayed is justice denied, right? So those are some of the reasons why this legislation is not only needed, but it is impactful, not just for this profession, but for all of our rural communities and citizens of Kansas. And I know others will speak in more detail to their own experiences, but I know time's limited, so I wanted to keep it as brief as possible for an attorney and judge that is not always, stood by, but I'm trying to stand by it today, and I will open myself to any questions at the appropriate time.
Thank you, Justice Wall. We appreciate you being here. Representative Mosley.
Thank you, Mr. Chairman, and thank you, Honorable Justice. I guess my first question would be, do you know how many counties have one practicing attorney in our state?
We have I believe 47 of our counties are defined as legal deserts, which means they have one or fewer attorneys practicing in the state. And that is probably understating the severity of the issue, because the data that our committee relied on is our attorney registration data. And so we're counting judges who don't actually practice law, right? Single employer attorneys that may just represent or serve as a county attorney and aren't providing services to the community at large.
I won't ask you the average age of those individuals where there's one person in the county or you're in an effective desert. Outside of the courtroom or finding yourself on the wrong side or possibly the right side of the law in like a criminal proceeding, what are other services that lawyers uniquely provide in a community?
Well, beyond the legal services they offer to the community, you will see them very actively involved in boards, community initiatives, economic development projects in the larger community. In terms of the legal services, you need folks that will take appointments to represent criminal defendants. You need county attorneys that can advise the county commissioners and prosecute criminal offenses in the county. You need private attorneys to handle farming operations, succession planning, estate planning. You have families where there are allegations of abuse and child in need of care, and we need those attorneys to represent the parents whose very right to parent their own children is now at stake. And to maneuver through the process without legal representation, when that's the type of issue before the court, is very frightening.
Thank you,
And
Mr. Chair.
if you did want to know the average age, I know the median age of our rural attorneys is much higher than in our urban counterparts. I believe the median age is 55, and it's several years lower in our urban parts of our state.
I'm in the land of we're lousy with lawyers in Lawrence, Kansas, so I can imagine what it looks like elsewhere.
Yes.
One more for Justice. Seeing none, thank you again for being here in committee. We do appreciate it. Thanks for your service in this initiative, and so thank you so much.
Thank you for your time.
Up next is Dr. Julianne Mazurchak, the president of Washburn University. Madam President, welcome to the Ag Committee.
Yes, thank you, Chairman Rogers and committee members. I appreciate the opportunity to speak today in support of Senate Bill 214. I do want to introduce, I have several experts here with me today. To my right, I have the Dean of our law school, Jeff Jackson. I have the Associate Dean of our law school that administers and is heavily involved in our rural law program. And then we have a nationally renowned faculty member in rural law that's joined us today, Roger McCohen. And they will be able to answer many questions if you have them at the end. Washburn Law currently offers a comprehensive rural law program. A summary of our program is attached to my testimony. Washburn and Kansas are leaders in rural law. Other states look to us for guidance about how to set up a comprehensive, effective rural law program. As you are likely aware, and as you have just heard, the shortage of attorneys in rural Kansas is alarming. We know attorneys in rural areas provide not only legal advice to individual client families, but also to their towns, often serving as a prosecutor or defense attorney while maintaining a private practice to provide legal advice on land transfers or estate planning, among a host of other matters. Additionally, they often serve in civic, religious, or community groups and are upstanding, engaged citizens who raise their families in rural areas. This proposed loan program will further facilitate our already robust efforts to place more law students in rural areas and should incentivize and encourage more law graduates to choose to practice law in rural areas by providing financial assistance to attorneys practicing in rural areas. We believe the impact of this program will be felt almost immediately and will help graduates choose rural law practice upon graduation. Washburn is ready to implement this bill as quickly as possible so the most rural attorneys can take advantage and we can help our great state of Kansas. And I'm pleased to answer questions at the appropriate time, and thank you for allowing our testimony today.
Thank you, Dr. Mazurchak. Any questions? Representative Schlangensieben.
Just a comment, I'd like to point out that Washburn University is within the 55th district that I represent and is a gem there. I attended it as a student in my first semester in college, and I appreciate your presence here, and we all know that Washburn has a stellar reputation in the area of law, so thank you for being here.
Thank you, Representative.
Okay, thank you.
Okay, thank you.
I think that's it. Also, if time allows, we have a video too on this that Dr. McCohen was featured on a national television show about that. So up next, Ann Sagan from the Kansas State Board of Indigent Defense Services. Welcome to committee.
Thank you. Thank you, members of the committee. Chairman, thanks for the opportunity to testify on this important bill. My name is Ann Sagan, and I am the Director of Special Projects at the State Board of Indigent Defense Services, and I also served as a member of the Kansas Rural Justice Initiative Committee. Our agency provides counsel to all Kansans who are facing felony charges but cannot afford an attorney. We do this through our public defender offices and through our assigned counsel program. Most of Kansas's rural areas do not have dedicated public defender offices and are served entirely by the assigned counsel program through which BIDS pays private counsel to take criminal cases. Unfortunately, rural Kansas is facing an attorney shortage, and this shortage will increase in the coming years as more and more attorneys retire and rural legal communities shrink. In my role as Director of Special Projects, I'm involved in our agency's attorney recruitment efforts. And in my experience, new lawyers who have just graduated law school are choosing urban and suburban areas to start their careers. It's difficult to recruit new lawyers to our semi-rural and rural offices. It's also difficult to recruit experienced attorneys to move to those areas to join our offices. And experienced attorneys are necessary to take high-level cases and mentor and supervise new attorneys. Unfortunately, many attorneys in rural areas are facing retirement, and within 5 to 10 years, the experience level of rural attorneys may be hollowed out. From a recruiting standpoint, BIDS will benefit from the implementation of both of the incentive programs in HB 2174. The Law Student Training and Loan Program for rural Kansas focuses on those law students who are starting their career and determining where to put down roots. The Attorney Training and Loan Repayment Program for rural Kansas focuses on attorneys who are already licensed and may have significant experience but need extra incentive to move their practice and their families to a rural community. Rural areas can utilize these two complementary programs to draw new attorneys and experienced attorneys to their communities. It's not unrealistic to say that in the coming years, we're facing a crisis of rural criminal defense representation. The lack of rural attorneys represents a looming problem as we face the possibility that we simply will not have enough defense attorneys in rural areas to represent criminal defendants. In most of rural Kansas, there is no public defender office and therefore no backstop to local counsel shortages. As shortages worsen, defendants could face wait times to receive counsel, or cases may be dismissed. This has already happened in Oregon, where the Associated Press reported that almost 300 cases in the Portland area were dismissed in 2022 because there simply were not enough public defenders to take the cases. Indigent counsel are essential to keeping our justice system working, but the rural attorney shortage doesn't just affect public defense. A shortage of attorney impacts everyone, including prosecutor offices, which are also facing staffing difficulties, small businesses, families, and agriculture, which all rely on the availability of attorneys in rural areas. Currently, BIDS deals with our attorney shortages by paying attorneys to travel hundreds of miles to represent defendants in rural areas that lack counsel. For example, one private attorney who takes BIDS cases may spend up to 5 hours on the road to reach a rural courthouse. She spent 33 nights in hotels over the course of the year as she navigated her many driving hours and courthouse schedules. This is a costly solution to the problem of rural attorney shortages, as the state of Kansas pays appointed counsel for their travel time and many miles on the road. Further, attorneys who live hours away are not able to meet with clients very frequently, and they're unable to take as many cases as local counsel would. This current practice of paying attorneys to travel to rural areas is not a long-term solution, it's a short-term one. And we must find a way to recruit attorneys to live and work in rural areas, not just commute there. Because of this, we support 2174 as an important pathway to bring much-needed attorneys to our state's rural communities. And thank you. I'm also available to take questions.
All right, thank you very much, Ms. Sagan. Any questions? Yes, Representative Singing. Got it. Singing. You know what I mean. Singing, sleeping.
Thank you, Mr. Chairman. I just have one question. We hear a lot about telemedicine these days, and I'm not making any suggestions here at all. I firmly am in support of this program. I just want to know, is there such a thing as telelegal services, and how far does that extend? I mean, does that even extend into the courtroom?
Well, so during the pandemic, a lot of courthouses and jails and attorney offices expanded their ability to meet with clients by Zoom or WebEx or other electronic means like that. And that has helped in some ways, because when you have a private counsel who may have to travel a long distance to come to a court hearing, but they're able to do a Zoom in for a short status update that really only takes maybe 10 to 15 minutes, that certainly has cut down in some areas that have that ability. Not every courthouse has that ability. Certainly every local jail does not have that ability. So it doesn't really help with meeting with rural clients necessarily. And it doesn't help with sort of like the bread and butter of most criminal trials, where you actually need to be in the courtroom. Your client needs to be with the attorney. You need to be able to consult on the fly and at a moment's notice, but it has helped.
Thank you. Thank you, Mr. Chair.
Thank you.
All right, very good. Other questions? Representative Mosley?
Thank you, Mr. Chairman, and thank you for your presentation. What is the average wait time for someone who is in need of indigent defense services, who has a high-level felony, like they murdered someone, or they're in like a, I guess, I don't know if it's called Class A felony. I should know this. I'm in corrections, but what's the average wait time for them?
So I think that does depend somewhat on what jurisdiction you're in. And whether or not we have a dedicated public defender office there or not. I don't have a number off of the top of my head to give you for an average wait time, but I can tell you that there is a staff member in our administration office who most of her job is connecting private counsel in some of these areas that don't have enough counsel to cases where they're needed, and it's usually high-level cases. So I don't have a number for you, but I can tell you that it is an ongoing problem and often takes a few days to get somebody who can represent somebody in a rural area where there isn't a qualified counsel.
Thank you.
Very good. Other questions? Seeing none, thank you.
Thank you.
Next, let's go to WebEx. Angela Meyer, an attorney. Welcome to committee.
Thank you for having me, and thank you for allowing me to testify in support of House Bill 2174. My name is Angela Meyer. I was also a member of the Rural Justice Initiative Committee. I am vice president for the Kansas Bar Association, and I am 15 years in a small town as a rural attorney. I feel like we need to paint a picture of what life is like in the proverbial trenches for a rural attorney. It's not uncommon in my office for me to spend nearly an entire day of my work week on the phone. There's never enough hours in the day, but that day is typically spent fielding 30 to 50 phone calls for predominantly family law matters, because that's the bulk of my practice, because there aren't enough lawyers to serve our area, which is the 7 counties in southeast Kansas for me. My practice is predominantly located in Pittsburgh, but it's not uncommon for me to travel to Montgomery County, or sometimes more than an hour and a half to 2 hours away, to be involved in a family law matter. Our entire dockets in Crawford County District Court, which is one of the larger counties in southeast Kansas, it's not uncommon for a day of a domestic docket, so paternity cases, divorce cases, to be spent where you don't see a lawyer in the courtroom. They're entirely pro se, meaning people without an attorney. Also, we have entire dockets of protection from abuse and protection from stalking matters that often don't involve lawyers. Kansas Legal Services provides an invaluable service to southeast Kansas, but there are more PFA and PFS matters heard than their own office can serve, and that most of those clients have difficulty affording a private practice lawyer. So that increases the security needs. It forces a victim to cross-examine their abuser, an abuser to be given the opportunity to cross-examine the person that they've hurt or injured or threatened. And it makes for increased difficulty in the legal process, difficulty for our courthouse security to ensure that everyone's safe during those days. The other aspect to that is that we also have cases where one party can afford or obtain an attorney and can get in quick enough into a lawyer's office for assistance, and the other party can't. And as much as we would like to think that legal process can serve anyone fairly without an attorney, it doesn't. It allows one party to be more adversarial, to be more familiar with the legal process, and it leaves someone without an attorney struggling to fight for time with their children or visitation or to afford their child support obligations under the Kansas child support guidelines. Additionally, like Justice Wall reflected, the numbers of how many licensed attorneys exist in Southeast Kansas reflects every person licensed to practice law. In some cases, that's 3 or 4 judges in that county or that judicial district, lawyers that serve and work in corporate counsel settings, or lawyers that are slowing down but haven't yet retired. So the numbers are really larger than they actually represent in terms of lawyers that are taking cases in a courtroom, able to prepare a will or a power of attorney, or meet with someone about their loved one's passing in the probate proceedings or divorce cases in my case. We contribute a lot, not only economically to our communities, but we contribute civically. We're often asked as rural lawyers to serve on more boards and volunteer for more causes than we have time for. I'm in charge and have been for now 11 years for the largest festival in Crawford County. It's near and dear to my heart, but it takes hours away from my practice. I wouldn't trade it for the world, but we're oftentimes the Hospital Foundation board members, the Humane Society board members, the historic buildings that have boards. Young lawyers and younger professionals in these communities step up to be involved in those organizations that contribute to festivals and events and all kinds of activities in our community. And as those numbers dwindle, the support for those causes dwindle. We also happen to also usually contribute financially to those organizations because of the success of our law practice. So economically, we do our best to put money back into the community to support our causes, but we need more lawyers in these rural areas for those causes and concerns to be addressed. I'm also a second business owner, so I have a full-time staff. I usually employ at least 2 college students that are interested in going to law school. As an undergrad alum of Pittsburgh State, I'm always encouraging our young social science students, if they want to go to law school, to come work in my office. But then I've also acquired and built a second business in my community that contributes sales tax and income tax back into state funds. There's a number of rural attorneys in Southeast Kansas that have cattle businesses and retail businesses or are serving as attorneys for those small businesses. And when our numbers dwindle, those resources, those opportunities dwindle, and it just stretches our communities thinner all the time. You know, the bill in front of you is a great core to start the process to recruit young rural attorneys or recruit attorneys from other areas to our rural environments. But it's one piece of that. The Kansas Bar Association has started a rural justice committee. QA has taken leadership. So don't think that this bill is simply the only fix that's out there. There are a lot of lawyer-based organizations that are rallying behind this cause to be the networking arm, to be the social arm, to be the logistics arm for this bill and this effort, because it's hard as a young attorney to go out on your own or be a new associate, to know people in the community when you're brave enough to relocate to someplace that you weren't born and raised or go back home. There's a different level of networking. In Crawford County, our Rural Bar Association takes a huge part in that, where we nurture and grow younger attorneys to practice here and stay here. So once they get involved in this program, there's a ton of organizations that will support their success, will be the phone call away if they can't figure out how to work QuickBooks or need somebody to help if they have the flu, because in rural areas, there's a level of camaraderie where if someone has an illness, if there's a death in the family, it's a phone call away to ask for help, and our lawyers step up to help cover, to help continue things, to be a technical support for when we don't know where to turn. I experienced that 8 years ago when I went out on my own and left the practice in Fort Scott and opened my own firm in Pittsburgh. And I still have those same connections and resources. We're a very tight-knit group, but we welcome people with open arms. I really, truly think this is the best step in the way to recruit rural attorneys to predominantly, fingers crossed, southeast Kansas, but all over the state of Kansas. And I'm
Right.
open to questions.
Thank you very much. Any questions for Ms. Meyer? Thank you. Thanks for being here. Appreciate it. And we'll continue to move forward. Up next, we'll go still on WebEx, Ashley Como. Ashley, are you there?
I am. Thank you, Chairman and
Yes.
members of the committee. Can you hear me?
Yes.
Okay. My name is Ashley Como, and I'm an attorney in Plainville, Kansas. I'm here today on behalf of the Kansas Women Attorneys Association, or KWA, to provide testimony in support of House Bill 2174. I currently serve on the KWA Council with my district representing 21 counties across Northwest Kansas. In the written testimony submitted by KWA, you'll find details about our mission to support and advance women in the legal profession. At its core, KWA's strength lies in connecting attorneys across the state. Practicing law is challenging in any setting, but the difficulties are amplified in rural areas. These relationships and mentorships are invaluable to rural attorneys, many of whom practice in isolation. KWA provides the much-needed support system, allowing us to share information, ask questions, and refer clients when necessary. But today, I think it will be most meaningful to share my own experiences, challenges, and what it would mean for my rural community if I had to leave. 10 years ago, I moved home to Plainville, leaving a mid-sized firm in Kansas City. My husband and I chose to raise our children near family, just 2 blocks from the Catholic school our son attends, and a half block from the public school that provides us with daycare. I serve on several committees and boards, and as a 5th-generation resident of Rooks County, I feel deeply connected to my hometown and my community, all reasons why it's great to be home. I work for Jeter Law Firm in Hayes, but I also work from a satellite office in Plainville. I have been the only attorney providing services in Plainville for the last 5 years. My husband is a paramedic for both Ellis County and Rooks County EMS, services that both struggle to fill their shifts. Outside of our full-time jobs, we also own several businesses. One such venture is Brandt's Meat Market, one of the 8 wonders of Kansas commerce, which we were able to purchase with Network Kansas e-community funds. With another company, we've renovated and filled 3 vacant properties in downtown Plainville, one of which was a Kansas Department of Commerce HEAL grant project. Through our full-time jobs and our businesses, we spend most of our days, nights, and weekends purposefully investing in our community. We love what we do, even when it's hard. My story is not unique, though. Many rural attorneys are committed to their small towns in similar ways. When I left Kansas City, though, I not only took a pay cut, I accepted that my long-term earning potential would be limited. I was a recipient of funds from the Rural Opportunity Zone program, which initially helped me manage my law school debt. While I'm grateful for the assistance, the funds were spread over 5 years and barely kept the interest on my loans at bay. ROZ is great for tackling undergraduate debt, but professional debt needs something more. Moving home has certainly benefited my community, my family, my children, but I want to emphasize that it has not been financially beneficial for me. Long term, my husband and I will face tough choices. What worries me the most is the tax bill that I will face at the end of my income-driven repayment plan, where my forgiven student debt will be treated as income and amount potentially more than double my current income. Of course, I'll plan responsibly for that looming tax burden, but it means we may have to leave rural Kansas when our children are older. I may have to consider higher paying jobs in urban areas or accept an offer to work remotely for better pay. Jobs that I've already been asked to consider, but so far I've declined. Technology in the legal profession has dramatically changed since I moved home, really since 2020, and the legal field is more adaptable to remote work than ever before. But that would mean one less attorney is providing local services. I don't want to leave my clients behind. Many already travel an hour or more to see me. Some of them come from as far as 3 or 4 hours away, actually. And asking them to find a new attorney even further away feels like too great a burden. Instead, I'm here on behalf of the Kansas Women Attorneys Association, myself, my clients, and my children to advocate for the constant improvement of the law and the legal profession. If passed, House Bill 2174 will have an immediate impact, not only for young attorneys, but also for many of us who are already out here in the trenches. House Bill 2174 would make law in rural areas more attractive and financially sustainable. Ensuring that attorneys choose rural and then continue to practice in rural communities is key to the administration of justice in Kansas. We fully support passage of this bill, and I'm happy to stand for questions.
Thank you, Ms. Como. She's in my district, by the way, so she's a great, I consider young attorney, so, and we thank you for coming home. Any questions? Seeing none, thank you for doing this, and I know we're under a time crunch, folks, but we'll do it the best we can, but yesterday's snow day is kind of done it this way, so thank you again, Ashley, for being on with us. Up next, Susan Richmeyer, Finney County Attorney. I believe, Susan, you're joining us via WebEx. Is that correct?
I am. I'm joining you from the road on a recruiting trip, actually. So.
Good. Welcome to committee. Go ahead.
Well, thank you, Mr. Chairman and committee. This is the exact reason why I am here, is because as a member of KCDAA, which is our Prosecutors Association, and I'm also a board member, we fully support this House Bill 2174 as being needed for those of us in rural Kansas especially. We're all suffering across the state from a lack of prosecutors. And I can fully support what Angela and Ashley have just said, because we deal with that on our end as well. And my colleagues tell me all the time that when they get a new phone call for a new divorce client, or someone that's a bank that's needing help with a foreclosure or some other financial thing, any corporations in town, they're like, it takes about 6 months for us to get somebody in to our office because we are so inundated with clients and we don't have the time to take on someone new. When that happens, it forces that business to go outside of our rural community, and it costs our citizens immensely to have someone travel from Topeka or Kansas City or Wichita to fulfill those needs. And so that, from the private side, I am very well aware of, and that is something that would help, as well as the fact that on the private practitioner side, they're not necessarily flush enough to hire a new attorney at a rate that those Kansas City firms or larger firms can do straight out of law school and provide the benefits available, where something like this would really help support those entities as well as our office as prosecutors to be able to hire people straight out of law school or those coming in already licensed, giving them that boost and extra something that would stand out against the larger salaries in the metro areas. I am very, very passionate about this particular bill and supporting rural Kansas, as I've been on the road a lot. For me, it's taking 6 to 8 weeks out of my year to do career fairs, panels at different universities, and doing on-campus interviews. And I've been doing this is now my 3rd year, and I have the first opportunity in ever to bring someone out of law school and hopefully into our office. So this is a long-term process that's required my county to go over and above what they should need to do in supporting my internship program, which is at a big cost to our county. But that's the only way we're able to ingrain these law students over the course of time. And that comes from those rural justice programs like Washburn provides. But this would be that next step, that hiring step that can give us the one up. And just to kind of put a little icing on the cake for anyone who's questioning, what does it look like for a rural attorney and how dire is this? My judicial district is the 25th. We have 6 counties in our judicial district. Finney County, which is where I'm located, we have roughly 24 total attorneys in Finney County. Most of those, I would say over half, probably 75% or 55 or over. That leaves a roughly 10 attorneys under the age of 45 to take over when those of us retire. And out of those over 55, more than half are in their 70s. We have one county attorney who is in his 70s, has been county attorney for probably 30 years, 40. I don't know how long he's been there. Well, probably since I was in high school. But he can't retire. He's the only one in Hamilton County. We don't have an attorney that resides in Kearney County. We don't have an attorney that resides in Wichita County. We have one practicing attorney in Greeley County, and we have 3 in Scott County. So anybody we need, and none of those are providing any defense work. So our defense work is going out of county, largely. I'd say 80 to 90% of our defense work is coming from out of county, and most of those are from Ellis County, which is 2 hours away from Garden City. So our cases, in answer to, I think, one of the questions before, our cases are delayed significantly because of that. We can get them through the court system. We have the time to do that, but the defense attorneys do not. So we're constantly continuing cases. We do use Zoom a lot. That should answer another one. I'd say for every hearing that we have that is not evidentiary in nature, if it's scheduling, those are done by Zoom. When they're evidentiary in nature and require testimony by witnesses, then those are requiring our attorneys to be there on the defense side. So that does require the travel. But we're looking at cases that are, I'm going to say 18 months to 24 months old in the criminal system that haven't had a resolution yet. And we feel like that's too long. It also doesn't allow for us, by not having prosecutors in the office, to necessarily keep our communities as safe as we would like to, because we have to bypass on the cases that we consider non-emergent. So those are all things that long-term can affect a community's safety and security, as well as business outcomes. So that is one of the reasons why KCDAA is strongly supporting this as well.
Okay.
I appreciate your time. I was trying to keep it short.
You're fine.
But I'll stand for questions.
All right, committee, just in the interest of time, if you have questions for Ms. Richmeyer, just let us know. We'll get them to you. So thank you so much. Okay?
Perfect. Thank you.
All right, committee, any other questions we have one more proponent, Anne Marie Yatsula, a student at KU Law. This is how you learn to be rapid closure. So you can do it in 35 seconds. No, go ahead.
I'll try to keep it brief, but I don't know if I can do that brief.
That's fine.
Thank you, Mr. Chairman and members of the committee. My name is Anne Marie Yatsula. I'm a third-year law student at the University of Kansas School of Law, and I'm here to express my support for this bill. I grew up in Tampa, Florida, a city that's part of a metro area, which is, as of the last census, had a larger population than that of the state of Kansas. Based on that fact alone, I'm the most unlikely person to be speaking here today in support of this bill. But my time at KU Law and the experiences I've had during my time as a law student have given me a desire to help our state address the access to justice problems it currently faces. I was able to get involved with the Kansas Supreme Court's Rural Justice Initiatives Committee during my second year of law school. I had attended the Southwest Kansas Bar Association's annual meeting in Dodge City as part of a trip with the law school, and a major theme of the meeting was how to recruit and retain attorneys in rural areas. I assisted the committee in data gathering for the report by moderating 2 focus groups with my classmates at KU Law. We discussed the benefits of a rural legal practice, like an ability to immediately get hands-on experience and to work with mentors. But despite those and other benefits, one thing came up time and time again: the financial hardships that can come with rural practice. According to the data gathered by the Rural Justice Initiative Committee, the average overall salary for Kansas Law School graduates was $73,003 in 2022. In contrast, rural Kansas attorneys graduating after 2021 reported an average salary of $59,000. That disparity reinforces what I heard from my peers. Rural work does not pay as well as urban work. And that is a huge concern when someone has student loans to repay. According to student loan survey data from the American Bar Association, around 80% of respondents indicated that student loan debt influences their choice of job or career in some way. Many of my classmates, myself included, are facing 6-figure total educational debt. It is a more prudent financial choice to take a better paying job when faced with debt of that scale. But something has to give. Across Kansas, people in rural communities are suffering from a lack of attorneys who are able to assist with legal issues from writing wills to resolving property line disputes. And for criminal defendants, a constitutional crisis is looming as there are fewer attorneys available to represent criminal defendants. Financial assistance in law school and beyond is crucial to making rural practice a viable, sustainable option. Similar programs for doctors and veterinarians have been in place for decades, and those programs have been effective at helping rural communities recruit and, perhaps more importantly, retain skilled professionals. Financial assistance is part of a much larger push for change in attorney recruitment and retention in rural Kansas, and the programs in this bill would help to solve one of the key problems, financial burdens. Thank you for taking the time to consider my testimony on this bill. If you haven't had a chance to read the Rural Justice Initiative Committee's report, I would highly recommend doing so. Some of the reflections and information from my peers is in that report as well. It might be of interest to you. Thank you again, and I'm happy to stand for questions at the appropriate time.
Thank you for coming over. Really do appreciate it. Good luck with everything, and I'm assuming you're going to come to rural Kansas, stay in rural Kansas. Is that right?
I'm actually working with the League of Kansas Municipalities, so I do help on a daily basis rural cities.
Right.
And it's a great passion of mine, so I'm glad about that.
Very good. One quick question, Representative Wagle. Oh, sorry. Your question for somebody else? Very quickly, yes.
Thank you. This question is actually for the Honorable KJ Wall, if you wouldn't mind answering a question. Yeah. Thank you, and thank you to everyone for being here today. I come from a county that is exempted from this legislation, but I still care very much about its success in rural Kansas. I have read the report that you guys issued about the plight in rural Kansas, and I really took note that there were other things in there that are barriers, including things like childcare access. And so my question to you is, how successful can this really be if we don't at the same time tackle really significant other issues that are also preventing young professionals from relocating, such as childcare?
That's an excellent question, and it's undeniable that those larger economic issues that impact all parts of rural Kansas impact every profession, including our own, and we stand willing to collaborate in solutions to those larger issues. But our focus was on, obviously, how we can make the biggest impact for our profession in a very strategic and focused manner. But there are also larger issues that obviously have to be addressed. Childcare, housing, those issues are common to all professions and all business owners across our state. Thank you.
Okay. Very good. Thank you so much. Oh, Representative Roth, right quick. Thank you.
I'm sorry. Thank you, Mr. Chairman. But just a point of information. I was just looking at the data for the population in Kansas, and anything west of Wichita, the counties have had no measurable increase in population, in fact, a decrease. One of the things that I've heard a lot of other professionals and people with professional certifications being short on, we don't have enough social workers, we don't have enough other workers, we don't have enough nurses, we don't have enough doctors. So when I first read this bill, I'm in support of it because it's going to help. But one of the challenges I think that we have is realizing that it's not showing any growth in the last 12 years out, except for Finney County has minimal growth, but it's not growing. And people's not going to go out there, or they haven't gone out there because of just what the previous conferee said, or maybe you said, you know, the dollars and cents, or no, you said the dollars and cents aren't working. Somebody said it, that they're only getting, for example, $50,000 when they can go to Wyandotte County and make $70,000 plus or more. And so, but it's realizing that the world is changing and the population centers are changing, and it's a real challenge for that. And so how do we do that? I'm not against this, but I'm for it. But the reality of it is we have to look that the population is changing and is not growing and anything east of Butler County is not growing either. So those counties aren't growing either. So
okay.
Thank you.
Appreciate it.
Yeah, sorry.
But we still need attorneys, even if there's 3 people, because we can't just create our own laws. So thank you very much.
Thank you.
All right, just quickly, written proponents, Wendy Grady, Farm Bureau, Etta Walker, Attorney Jay Hall, Kansas Association of Counties, John Goodyear, Kansas League of Municipalities, Jocelyn Krissick, I believe an attorney, Marilyn Harp, I scribbled something, but she's an attorney, I believe. Nicholas Lewandowski from the Farmers Union, Sarah Shattuck, attorney, Tabitha Owens, Smith County attorney, and Joseph Molina for the Kansas Bar Association. Any other proponents? Seeing none. Any opponents? Seeing none. Any neutrals? Seeing none. We'll close the hearing on House Bill 2174. Okay, we have, I text Propes Chair, Waymaster, we may go just a little bit long, not too long, so we will open the hearing on House Bill 2021 well, it is on the ethanol blend. So Kyle, if you can give a brief on this bill. 2012, I'm sorry, House Bill 2012.
Thank you, Mr. Chairman, members of the committee. Under House Bill 2012, a tax credit would be allowed against the tax liability for retail dealers and distributors selling higher ethanol blends in Kansas for taxable years 2026 through 2031. The credit amount would equal 5 cents per gallon of higher ethanol blend sold and dispensed through metered pumps at a service station or when distributed directly to a final user located in Kansas. Unused credit amounts could be carried forward for up to 5 taxable years following the year the credits were allowed, but the credits would not be refundable. The total amount of tax credits issued per year under the Act could not exceed $5 million. And then just some key definitions really fast. Distributor would mean a person, firm, or corporation doing business in Kansas that produces, refines, blends, compounds, manufactures, imports, or distributes motor fuel. Higher ethanol blend would refer to fuel with 15% to 85% ethanol capable of being dispensed directly into motor vehicle fuel tanks. Retail dealer would mean a person, firm, or corporation doing business in Kansas that owns or operates a retail service station in the state. And then finally, retail service station would mean a location in Kansas selling higher ethanol blend to the public dispensed directly into vehicle fuel tanks. House Bill 2012 would become effective upon publication in the statute book. I'd be happy to take any preliminary questions.
Seeing none, Kyle, we're going to hold off on that. Heather, a quick fiscal note on the way the bill is right now.
Real quick, the bill would reduce state general fund revenues by $5 million per tax year beginning in tax year 26 and 27. The department indicates they would need $219,000 from the state general fund for administrative costs.
Okay, we're going to hold off on questions. Now, before we get started, I want to make sure the committee is aware. This bill was in tax. It was given to us. And so what we are doing, we are working on a balloon amendment. It will become a grant program. There are a lot of moving parts, and so we're not quite ready to do that. We will do that when we do the, when we work the bill. Being in tax, it is an exempt bill. We will not work this till after turnaround. So just want you to all be aware. So the testimony talks about tax credits. The tax credit part will be going away. It's going to be a grant, and then we will share all that. You will have plenty of time to ask questions and conferees. We will probably want you back because, you know, we do things a little different here where we want to have interaction to make sure all our questions are answered. So with that being said, let's go to our first proponent, Randy Stuckey from Renew Kansas Biofuels. Welcome back to committee.
Thank you, Mr. Chairman, members of the committee. Randy Stuckey this afternoon before you on behalf of Renew Kansas Biofuels Association. So you've just heard the brief of the bill that will be a different bill when you go to work the bill. But in principle, it's the same idea. So before you this afternoon on behalf of the biofuel producers in the state of Kansas. So our interest in this bill broadly is that my members produce ethanol in the state of Kansas. There's about 12 ethanol plants located across the state, mostly in rural areas, but all of which receive corn grown in the state of Kansas and sorghum grown in the state of Kansas to produce that beautiful ethanol that we sell and use in our vehicles. That's our purpose and interest in this bill. And just a little bit about what the bill does. It's a model bill that has been used and passed in years past, and in the last 4 or 5 years, all across the Midwest and other very ethanol and corn-heavy states. The purpose of the bill is to ensure that the corn grown in those states, just like in Kansas, the demand for that corn is strong and supported by increased use of ethanol in the gallons that are used in motor vehicles. What the bill does, it incentivizes retailers, now here in the state of Kansas, it would, to sell E15. E15 is 5% higher ethanol in the gallon of motor fuel than has been used since 2007. You'll know that recognize that as E10. E10 was a federal requirement that every gallon of fuel sold in the state of Kansas, or across the United States rather, unless you purchased an offset, had to have at least 10% ethanol in that gallon of motor fuel. Now, you can still buy E0. You know this when you go to your retailer. You can buy E0, meaning there's no ethanol in that gallon, or you can buy E10. Well, E15 is the next step in that motor fuel for ethanol. Now, E15 has been approved since 2001 by the EPA. So that is 95% of the motor vehicles on the road today, 95% that drive. So if you have something older than 2001, it's not recommended for your vehicle, so you wouldn't purchase it. But the market today that we want to support, to use to support corn grown in Kansas, we need E15. Now, just this last quarter, we've had the highest exports ever of ethanol out of the United States. That's great when we have exports. But right now, the export market looks to be a little shaky, and for various reasons. And if we don't have those exports, we are capped out demand on E10, which means we have to have, for domestic purposes, an E15 market. You say, okay, great. Let the free market take care of it. We agree with that too. This is not a mandate. The purpose of this bill is to incentivize additional retailers here in the state of Kansas, just like in the other states that have passed this, to offer E15 at their pump. Now, some of the retailers can do that today, just to replace E10 with E15. Some of them, the older stations, might need to replace some equipment. That's going to take some upfront costs. To be sure, there are more and more retailers all the time offering it. I think the number today, though, is about 150 retailers out of the 2,000 in the state currently offer E15. If we don't have more retailers offering E15, we're oversupplied right now on ethanol in the United States. That goes back to the export market. We are oversupplied at E10. If we don't expand the E15 market, we're going to be pulling back on production. Now, that might not resonate with you, but Economics 101 says that if you don't have demand on ethanol, the corn that's grown in the state of Kansas, 1/3 of that corn, 1/3 of every bushel of corn and sorghum, sometimes more, that's grown in the state of Kansas is used for ethanol production. If you weren't aware of that, now you are. 1/3 of every bushel that's grown in the state of Kansas is used for ethanol production. So it matters. It matters to my industry, to be sure. It certainly matters to the farmers, the corn farmers and sorghum farmers in the state of Kansas, that we have a strong and growing ethanol market. But eventually, it's going to matter to the bottom line for the state of Kansas if we have a reduction on demand and then price for corn grown in the state of Kansas.
All right, Randy, thank you so much.
Thank you.
If there are questions, we'll hold to the end, and we'll have about time for maybe two. So thank you so much.
Thank you.
Up next, Taylor Williamson from Kansas Corn Growers. Welcome back to committee. And the airlines made it so you could get back, huh?
Yeah, I actually drove. So I left the hotel in Dallas this morning at 4:30. I kind of joked earlier that I appreciated the weather actually allowing me to be here. I wouldn't have been able to be here yesterday, so that's why you guys get to see my smiling face. But Randy did about as good a job as anybody in describing why we need ethanol, but I think for Kansas's corn part, we're pretty committed to pushing more ethanol, getting more ethanol. We see that there's benefits to not only farmers, but to the consumer, to the environment, to everybody involved. So since 2016, Kansas Corn has helped small retailers especially installing higher blends of ethanol. We run a grant program that, or we write grants for small retailers that are looking to implement higher blends of ethanol infrastructure. So there's a USDA program called the Higher Blends Infrastructure Incentive Program that we pro bono write the grants for, allow a lot of retailers to be able to access those funds. As well as we've also had a history of administering grants and helping to build infrastructure. We help fund some retailers in California that put in additional E85. There's a lot of effort that the Kansas Corn Growers and the Kansas Corn Commission, as you guys would have heard a couple weeks ago, there's a lot of effort that we have all gone to try to advance additional ethanol. So as Randy mentioned, E15 approved for all vehicles 2001 and newer. That's over 96% of the cars today, and that number increases every single day. It's about 15 cents cheaper than regular unleaded E10. And then for the higher blends that can go into your flex fuels, you're looking at up to $1 cheaper. So whether it's in a rural community, whether it's an urban community, you're saving somewhere between 15 cents and $1 per gallon anytime that there's higher blends of ethanol in there. The ag benefits, Randy nailed this. It's a third of our corn goes to ethanol plants. It also is food and fuel. So when an ethanol plant turns that corn into ethanol, there's a byproduct called dried distillers grains. That's a very high protein, very good use for cattle feed. So not only do you get the fuel part of it, but then you are able to then consume that corn through cattle. Kansas consumers purchase about 1.1 billion gallons of fuel per year, so a 1% increase in the blend rate equals 16 million gallons of ethanol, which is 5.7 million bushels of corn. So if we can just get marginal increases in the amount of ethanol that's consumed out there, you're seeing massive benefits that go directly back to the farmer. And then last thing I want to touch on is just the environment. So according to several studies, USDA, Harvard's, Tufts, ethanol decreases greenhouse gas emissions by 46%. So as we're moving forward, we feel that ethanol is not only good for farmers, it's good for the consumers, good for the environment, and then good for the economy of Kansas. Absolutely.
If we have time at the end, we'll follow up. Also, Michael O'Donnell. Up next. Welcome to committee.
Thank you, Mr. Chair. Thank you, committee, for allowing this hearing to happen today. I know this has been the most favorite thing that Chairman Rajas has been dealing with over the last couple of weeks. I represent Jumpstart Stores. They're based out of Wichita, Kansas. And Mr. Filnier apologizes he wasn't here. He came to the hearing that we had in Tax Committee 2 weeks ago. I believe you have written testimony from he and from Mr. Dave Vandergren from ICM. Phil had me send that there. But we just come in strong support of this bill. We actually like it better that it's a grant program. It's easier to administer. It's easier to follow through. Jumpstart was founded 13 years ago. We have over 30 stores in the South Central Kansas region. We have just grown. We now are as far east as Abilene, and now we have stores as far away as Great Bend and Hoisington. But we blend our own ethanol at the pumps, and I believe Randy was saying we are the #1 distributor in the state, supplier in the state of higher blend ethanol gasoline, and we have a lot of plans to grow in the future. Our model has been we go in, we find underperforming stores, we remodel them, we rebrand them Jumpstart, and it has been a wonderful addition to not just the ethanol industry, but to small towns when we've gone into places like Towanda, and that had been a closed convenience store for years down in South Wichita, other areas. So we'll take an old convenience store, remodel it, and turn it into a very nice feature for that community. So we look forward to expanding in Kansas for years and years to come. And this would be a great model for us to use. Our neighboring states all have it, so it will not Oklahoma, but Nebraska has it, Iowa has it, Missouri has it, Indiana has it. So this isn't, we're not reinventing the wheel. So we come in strong support of that. So thank you very much for your time, and we'll stand for any questions.
Thank you.
Thank you.
Very good. Sandy, did you want to testify or not?
Oh. Sandy Braden with Poet Biofuels out of Wichita, and I'll defer my time to Brian from the region.
Okay. Very good. And Sadie Braden, who representing Poet, so that testimony is in there. And then Brian Postler with True Fuel Time, correct? Is that right? True Fuel? There we go.
Right, Fuel True.
Fuel True.
Mr. Chairman, thank you.
Okay.
Good afternoon, committee. I appreciate you taking a few minutes for my testimony today. The state of Kansas has a vested interest in more higher blend ethanol production. Increased ethanol is wonderful in lots of ways. It is renewable, it's sustainable, it's a crucial part of the all of the above strategy for energy independence. And so it's good for ag, it's good for Kansans, but it's also certainly good for retailers who can offer it, but it's especially good for consumers who are driving. Right now, many Kansans are feeling the pinch of higher energy costs. One of the beautiful things about higher octane ethanol is it allows you to have higher octane at lower prices, right? So that's great for drivers in lots of ways. The problem, though, so if it's so wonderful, if it's renewable, sustainable, it's high octane at lower cost, why aren't only 150 retailers offering it? And the answer is because there's some pretty significant upfront expenses if you're going to offer higher blend ethanol. The higher the blend, the more corrosive the product. And the more corrosive the product, it's hard on tanks, it's hard on lines. You need special tanks, special lines, better dispensers. You need all those kinds of things like Jumpstart puts in order to offer this. So it's hard to incentivize retailers to bear those costs when it's such a competitive industry. So this is one small step to help us do that. It's not going to pay all those bills up front, but anything we can do that can make a slightly higher incentive for retailers to offer the higher blends, the more likely we're going to see more of them happening at the pump. And so this is a good first step. I can also promise you that retailers will be able to pass some of those savings on directly to consumers. And why am I confident of that? My industry is probably one of the only one in the entire state that is foolish enough to put our prices in 3-foot-high numbers out visible at the curb. And so it's highly competitive because I know some of you do this. You will drive 2 extra miles to save 3 cents, right? And so if we can drop the price by 5 cents, that makes a difference. And in our competitive environment, our retailers will pass that on to consumers. So with that, do please report this favorably, and we'll be glad to see you when you work it. Thank you.
Thank you, Brian. Sure appreciate it. Okay. We're just going to hold off on questions. If you have questions, we will follow up with those and hope you all come back when we work this bill. Also, Chris Bliley, written only proponent, Claudia Hisson, Kansas Farm Bureau, David Vandergrant, ICM, Phil Neer, and Shahira Safford with the Co-op Council. Anyone else wishing to testify as a proponent? No, change. Okay, any other opponents? Seeing none. Anybody neutral? Seeing none, we'll close the hearing on House Bill 2012. We will not do any bill working today, and also we will get you that. We ran out of time for the video on the rural attorneys, so you'll be able to see that as you will. It's about a 5-minute video. We just ran out of time. Okay. Here's what we are going to have a hearing tomorrow on 2 bills. Shouldn't take that long. We are going to work 4 bills tomorrow. So, House Bill 2255, that's the Weights and Measures Bill. 2064, that's the Solid Waste Land Spreading. That's the first bill we heard. House Bill 2095, the Pump Installers Bill, License Bill. And then House Bill 2111, the Acreage Increase for CREP. Now, on Monday, we are planning on working House Bill 2172, that is the Water Task Force Bill, and House Bill 2254, that is the Milk Trust Bill we heard today. That is the plan for today or for tomorrow and Monday. Also on Monday, the state committee, the state FFA officers will be here as they do every year. And Monday will be the last day before we go on the floor. Anything else for the good of the cause? Seeing none, before we adjourn, we need to exit. If you're here for a propes, stay here, and then some of us need to shift our chairs. So with that, we are adjourned.